The Supreme Court just did something that every gun owner in America has been waiting decades for. And I'm not talking about a minor adjustment, a tweak to processing times, or a reduction in fees. I'm talking about the complete and total dismantling of the government's ability to require your permission to exercise a right the Constitution already guarantees you. Concealed carry licenses, purchase permits, ownership registration cards, firearm identification requirements, all of it, on the chopping block. And the reason this is different from every other legal story you've seen come and go is this. For the first time in modern American history, the federal government itself, the Department of Justice, is standing right alongside gun owners in front of the Supreme Court and saying that permit systems are unconstitutional. Full stop. No exceptions. Stay with me, because what I'm about to lay out will change how you see this entire fight. Let's start with the word nobody in mainstream media is taking seriously enough: emergency. The Supreme Court receives somewhere between 7,000 and 8,000 petitions every single year asking them to hear a case. Out of those thousands, they accept roughly 60 to 80. That alone is a filter so tight that getting your case heard is itself a legal achievement. Emergency status is something else entirely. When the court fast-tracks a case to emergency review, they are not just saying the issue is important. They are saying the constitutional damage being done right now, today, is so severe that normal timelines are unacceptable. They are saying every single day this continues is another day Americans are living under unconstitutional conditions. They have done this for maybe 5 cases in recent memory. This is one of them. 130, so. The constitutional chaos that forced this moment. To understand why the court had no choice but to act, you have to understand the absurd reality that exists in America right now. 27 states already have constitutional carry. In those states, law-abiding citizens don't ask permission. They exercise their rights. But in the remaining 23 states, your ability to exercise your Second Amendment rights depends entirely on whether a government official approves your application. You pay fees ranging from $150 to over $800. You wait weeks or months, sometimes longer. You complete mandatory courses. You submit to background processes. And at the end of all of it, an official can still deny you, sometimes without even being required to explain why. Think about what that means in practice. The exact same conduct in a law-abiding citizen carrying a firearm for self-defense is a protected constitutional right in Texas and a potential felony in New York. Same country, same constitution, completely opposite legal realities depending on which side of a state line you're standing on. Legal experts call this constitutional chaos. The Supreme Court exists for exactly this reason, and they are finally acting like it. The legal argument that forced the court's hand is devastatingly simple, and that simplicity is exactly what makes it so powerful. You cannot require government permission to exercise a constitutional right. That is it. That is the whole argument. And the more you sit with it, the more obvious it becomes that the argument is correct. Think about what we have been silently accepting for decades. Imagine if tomorrow your state announced that to attend church, you had to submit an application, pay a $300 fee, take a mandatory 16-hour class, and then wait 8 weeks for a bureaucrat to decide if you were allowed to pray. We would recognize that as insane immediately, because we understand what the word right means. A right is something you possess by virtue of being a citizen. A privilege is something the government allows you to do. The Second Amendment was never meant to be a privilege. But the case that actually sent shockwaves through Washington didn't start at the Supreme Court. It started with one federal district court judge who did something the entire legal establishment did not expect. He didn't narrow a permit requirement. He didn't order faster processing or lower fees. He looked at an entire state permit system and declared it unconstitutional on its face. That phrase, unconstitutional on its face, is one of the most powerful findings a court can make. It doesn't mean the law was applied badly in one particular case. It doesn't mean the state needs to fix a few provisions. It means the entire structure at its very foundation violates the Constitution. There is no version of this law that could ever be constitutional. The whole thing has to go. His reasoning didn't rely on modern interpretations or evolving legal standards. He went straight to the historical record, the actual founding era, the actual early republic, and asked a simple question. Did the founders require permits for firearms? The answer he found was unambiguous. 0. Not a single historical example of the founding generation requiring government permission to own or carry firearms. People simply possessed firearms as a natural, inherent right. There were no applications, no fees, no approval processes, no gatekeepers. Then he found something in the historical record that gun control advocates have spent decades trying to keep out of mainstream conversation. Permit systems didn't emerge from genuine public safety concerns. They emerged in the early 1900s with documented, explicit roots in racial discrimination. Southern states after Reconstruction designed permit schemes with one specific purpose: to prevent Black Americans from exercising their right to bear arms after emancipation. Northern cities like New York designed discretionary licensing systems, specifically targeting Italian, Irish, and Eastern European immigrants that political establishments viewed as threats to their power. These were not safety laws. They were oppression tools wearing the costume of government regulation. When the state appealed immediately, fully confident the circuit would reverse the ruling, what happened instead stunned everyone watching. A 3-judge panel not only upheld the injunction, they wrote an opinion that dismantles the philosophical foundation of every permit system in the country. Their core finding: the moment government makes a constitutional right contingent on official permission, that right ceases to be a right. It becomes a privilege. And the Constitution doesn't create privileges, it protects rights. When the state demanded the full circuit reconsider, every single judge declined. That's not a procedural footnote. That is the entire court signaling that the panel reached the correct conclusion. Now combine that with conflicting rulings across circuits, the 2nd upholding New York system, the 9th upholding California's, the 4th approving Maryland's, and you have a full constitutional crisis the Supreme Court is now obligated to resolve. But what truly accelerated this case to emergency status was something that hadn't happened in modern American legal history, and it came from the last place most people expected. The Department of Justice, under Attorney General Pam Bondi, just staked out a position on Second Amendment rights that no federal government has ever taken before. They didn't file a brief asking for modest permit reforms. They didn't argue for streamlined processing or clearer standards. They walked into the Supreme Court and told the justices, in plain language, that any permit requirement, any system whatsoever that requires government pre-approval before a citizen can exercise Second Amendment rights, violates the Constitution. Not some permits, not poorly designed permits. All of them. Every single one. The DOJ's core argument cuts through every counter-argument like a blade. Constitutional rights are not conditional. They do not require government approval. They do not come with fee structures. They are not subject to bureaucratic timelines. The moment you attach those conditions to a right, you have transformed that right into a licensed privilege, and that transformation is unconstitutional regardless of how reasonable the individual conditions might seem. They made a comparison that is almost impossible to argue against. Americans don't need a permit to speak freely. There is no application process to practice your religion. No government official reviews your request before granting Fourth Amendment protections. No fee schedule exists for Fifth Amendment rights. The Second Amendment exists in that same document, ratified by the same founders, and there is no constitutional basis, none, for treating it differently than every other enumerated right. Then the DOJ did something that completely undercuts the safety argument permit advocates have relied on for decades. They brought the data. When Texas moved to constitutional carry, violent crime didn't skyrocket. It dropped. Florida tracked numbers moving in the same direction. Tennessee eliminated permits in 2021 and tracked a significant reduction in violent crime over the following 2 years. These aren't projections or models. These are actual results from states that ran the experiment and reported the outcomes. The permit system, as Bondi's DOJ is arguing, doesn't stop criminals. It only acts as a crushing barrier for law-abiding families living paycheck to paycheck in high-crime neighborhoods. The people who need self-defense the most, yet are the ones who can least afford an $800 permission slip from the state. The brief also raised a civil rights dimension that rarely gets the attention it deserves. Permit fees ranging from $150 to $800 combined with mandatory training costs and time off work create a financial barrier to constitutional rights that falls hardest on exactly the people who need protection the most. The system, in practice, prices the most vulnerable Americans out of their constitutional rights, while creating no meaningful obstacle for the wealthy. Over 25 states filed in support, the largest state coalition ever assembled for a Second Amendment case in Supreme Court history. And here is where I need you to pay very close attention. Because while gun owners are celebrating, something is already happening in state capitals that most people have no idea about. Anti-gun states are not waiting to see how the Supreme Court rules. They are actively drafting contingency legislation right now, today, designed to preserve every practical restriction that the permit system currently creates, while technically appearing to comply with whatever the court decides. This isn't paranoia. This is documented political strategy that has been deployed before. After Bruin was decided in 2022, New York didn't accept the ruling. They changed their law to reconstruct as many restrictions as possible within whatever space the ruling left. They have now perfected the art of nominal compliance that achieves actual defiance. What is being planned this time is more sophisticated than anything they have tried before. California's strategy is already in draft form. The plan eliminates the formal permit, the document that would be unconstitutional under a broad Supreme Court ruling. In its place, the state would create a mandatory firearm safety certification program. On paper, it looks like a training credential rather than a permit. In practice, it requires the identical background check infrastructure, the identical fees restructured under new line items, the identical waiting periods reframed as certification processing times, and identical grounds for denial now classified as certification failures. Same gatekeeping, same financial barriers, same government approval requirement, different letterhead. New Jersey's approach is, if anything, more deceptive. The plan being circulated would eliminate ownership permits entirely, and the governor would hold a press conference celebrating full compliance with the Supreme Court. But buried deep in the legislation, attached as an amendment to existing ammunition regulations, would be a requirement for government approval on every single ammunition purchase. Every box, every time. You could own the firearm without a permit. But without continuous government permission to buy ammunition, the right to bear arms becomes theoretical rather than practical. They are not restricting the gun. They are restricting what makes the gun functional. Illinois is exploring a mandatory liability insurance requirement that would replace the permit process. The annual cost would be structured, through coordination with friendly regulatory decisions, to fall in exactly the same range as current permit fees. The genius of the scheme, from their perspective, is that the state never directly denies anyone. If insurance companies choose not to offer coverage in Illinois, or price policies beyond what ordinary people can afford, the state simply points to private market decisions. They maintain plausible distance from the outcome while achieving the identical result. Most people cannot practically exercise the right. And then there is the sensitive places trap, which is the most likely first move you will see from multiple states within 30 days of the ruling. They will say, fine, you don't need a permit to carry, but you can't carry anywhere. They will designate every park, every sidewalk, every place of business, and entire city blocks as gun-free zones. By expanding the definition of a sensitive place to include virtually the entire public square, they effectively ban carrying a firearm without technically requiring a permit. It is the same wall, just with a new coat of paint. This brings us to the most important legal question surrounding this entire case. The difference between a ruling that actually changes something and a ruling that gets neutralized within 30 days comes down entirely to how broadly the court writes its opinion. A narrow ruling, one that simply says the specific permit system being challenged is unconstitutional, leaves enormous room for every workaround being planned. States would immediately pivot to their contingency legislation, spend years in lower court litigation over whether the new system is different enough from the old one, and effectively delay real compliance for the better part of a decade. A broad ruling is the only thing that forecloses these schemes before they can be implemented. That ruling would need to establish several things explicitly: that any system requiring government pre-approval before a citizen can exercise Second Amendment rights is unconstitutional, regardless of what that system is called, that any fee structure creating a financial barrier to a constitutional right violates equal protection, that any government-controlled process designed to create delays in exercising constitutional rights is impermissible regardless of the administrative rationale, and that substituting one approval mechanism for another, calling a permit a certification, calling a license an insurance requirement, does not change the constitutional analysis one bit. Write the opinion that clearly, and you don't just win this case. You close the loopholes before state legislatures can drive through them. The DOJ under Pam Bondi is already preparing injunction templates, pre-written lawsuits ready to be filed the second these states pass their fake compliance bills. But until those lawsuits make their way through the courts, you, the gun owner, will be the one caught in the middle of the legal crossfire. Legal scholars following the case closely believe there is genuine reason for optimism. The fact that the court accepted this on emergency status, combined with the DOJ's sweeping position, suggests the majority may be prepared to write exactly the kind of comprehensive ruling that would make these contingency plans unworkable. So let's talk about what this actually means for you and what you need to do right now, because this is moving incredibly fast. If you live in one of the 27 states that already has constitutional carry, this ruling has the potential to constitutionally entrench and protect your system in a way that makes it significantly harder to reverse in the future. That matters because political tides change, and having a Supreme Court precedent as a backstop changes the legislative math significantly. If you are in a permit-required state, your situation is about to change. But the timeline and the practical reality of that change depends almost entirely on how your state government responds. And based on everything being drafted right now, several states are planning to make that change as minimal as possible. The states most likely to deploy immediate workaround strategies are the ones with the most established infrastructure for permit resistance: New York, California, New Jersey, Illinois, Massachusetts, Maryland, and Hawaii. If you live in one of these states, do not assume a Supreme Court ruling automatically changes what you experience at the practical level. The machinery for nominal compliance is already being assembled. Here is your checklist for the next 90 days. First, connect with your state-level Second Amendment organization right now, because they will have the earliest and most accurate information on how your specific state legislature is responding. Groups like the Gun Owners of America are already tracking the backdoor schemes. Second, monitor your state's legislative tracker for any bills introduced in the 30 to 60 days following the ruling. That is the window when contingency legislation is most likely to appear. Third, do not assume compliance. Just because the Supreme Court rules does not mean your local officials got the memo. Avoid being the test case during the transition period. And fourth, even if permits are eliminated, document your training. In a resistance state, if you are ever involved in a self-defense situation, having documented training proves you are a responsible, law-abiding citizen. The Supreme Court is on the verge of delivering the most significant Second Amendment ruling since Heller. The legal foundation being built by the plaintiffs, by the DOJ, by a coalition of more than 25 states, is stronger than anything the gun rights community has assembled before. The constitutional argument is clean, the historical record is clear, and the practical evidence from constitutional carry states directly contradicts every major claim made in defense of permit systems. But a Supreme Court victory and a real-world victory are only the same thing if the ruling is written broadly enough and enforced aggressively enough to prevent what is actively being planned right now. The next 90 days will determine whether this moment becomes a genuine turning point in American constitutional history, or whether it becomes the latest example of a paper victory that state governments successfully defang before most people realize what happened. Subscribe and turn on notifications right now, because the moment that ruling drops, the clock starts on these workaround bills, and if gun owners are not paying attention from day one, states will have their systems restructured before the legal challenges can even be filed. Drop a comment and tell me what state you are in, and whether you think your local government will comply honestly or whether they are already planning a workaround. Because what your state does in the 30 days after this decision comes down is the story that actually matters. The ruling may be coming. The battle for enforcement has already begun.